you put it in a will, in a legally binding document. That's really all you can do in the States to fulfill your obligation to distribute it according to the Quran, according to the Sunnah. So now the first question that comes up is, what happens if someone dies without a will? The basic answer is, you don't have control of who gets what and what portions. Because if you die without a will, you're not there to say, I want my house to be transferred here, I want this person to access my bank account, I want this person to be able to sell my business, because you didn't leave a will. So there's something called Texas intestate laws. These come into place automatically if you die without a will. It's the state of Texas has laws saying if you die without a will, based on who's living at that time, this is who gets it. So it's similar to the Quran saying if you pass away, this is who gets it in these portions. Texas has its own model, which is automatically contradictory to the Quran. So basically, they govern how the assets are distributed without a will, and you lose control of who gets it and in what portions people get it. So you have no say in that. All right. Thank you. And generally, your family has no say in it. On top of that,
If you can wait the mic,
yeah. That's right. Okay. Okay, on top of that, if you die without a will, there is a court process that happens in probate court. This happens if you have a will or you don't, but if you don't have a will, there's a few different, not sure what's going on here, sorry about that.
It's good.
It's good?
You're good, yeah.
Okay, so there's a few different processes that happen if you don't have a will. You need the mic? Okay, I'm not sure why it's not working. Sorry about that. All right.
No.
All right, thank you. Here, I'll just hold it. Okay, I appreciate it, thank you. Okay, can you hear me okay? Okay. So if you die without a will, the court process that happens, the court wants to make sure that the beneficiaries or your family that is supposed to inherit it is there and living. So they do dependent administration. Basically, they monitor all the actions of your estate for each item that's sold in a determination of heirship. They determine who your beneficiaries are. So they usually appoint an attorney ad litem, basically someone for the minors in case they're worried about fraud, in case you say, no, I'm the only surviving beneficiary. They want to do their own due diligence, but you unfortunately have to pay for all that process. And they determine these are the beneficiaries. Now you have to sell the assets to these people, and they monitor every asset that's being sold. In general, it's just a more costly probate process, and it takes a really long time unnecessarily. So that's generally what happens to make sure that, that there's no fraud and to pass your assets. The biggest one is the bank accounts. If your name is the only one on there, they freeze it until this process is done, and then there's a court order saying who has authority to access it. Now, this is all if you die without a will. Now, one of the basic estate planning tools is the will. If you don't have anything, you should at least have a will. And this gives you a choice of everything. So you choose what kind of funeral rites you want. If you want an Islamic funeral, charitable contributions. Islamically, you can give up to 1/3 after your expenses, debts are paid off, and your beneficiaries. So you can say, these are my beneficiaries in these portions. So you have control to distribute it Islamically, or just generally you pick who you want in what portions. And then you also choose the executor of the estate. The executor of the estate is different than the beneficiary. So the beneficiaries are who's getting your property and in what portions. The executor is the person that has authority to step in your shoes and sell your assets on your behalf as if it was you. That could be the same person as the beneficiary, but it doesn't have to be. So let's say for me, I pick my wife to be my executor, but she's also a beneficiary. So she's the one that's gonna have the court order saying, anything I can do, she can do. She can sell my house, she can go my accounts, but she has to distribute it according to the will. She has to give it to the kids in those specific shares. And then in here you can choose independent administration as far as how the probate proceedings go. So if you remember here, we said dependent administration is a probate proceedings where the court supervises you heavily on every asset that's sold. And here with the will, you do independent administration. You still go to court, but it's a very smooth process. In my example, my wife is the executor. She takes my will to the court. It says she's the executor, and I prefer independent administration. They give her an order. She can do anything she wants with my assets, sell them, and then she goes back to court when everything's done and says, it's all finished, I've done everything, with very minimal court supervision. So it makes it very efficient, makes it very cost effective, lower attorney fees, lower court fees, and it's a very quick process. Now, that was the will. That's a very basic one everyone's familiar with. Now, the second type is the trust. A lot of people have been really doing these a lot more than wills lately. It's because they avoid the court process. So what it is, it does everything the will does. And I'm not sure, you might not be able to see that clearly, but the only difference with this, so you choose your funeral rights, your beneficiaries Islamically, charitable contributions. Instead of the executor, the person that has the authority to transfer your assets, you choose a trustee. It's the same thing, it's just different terms. And there's no probate process. So you avoid probate with this. You get all the benefits of distributing everything the day after your death without probate. So basically, I know it's a very small screen, I apologize, but if you see it, it's the same thing. You just avoid the probate process in the middle. The theory is you create this trust. It's like a contract. For instance, me and my wife are trustees or managers of the trust. We put all our assets in there. When one passes away, the other is a trustee and passes out my assets to the beneficiaries Islamically. When the second passes away, we name another trustee. We name my brother, for instance. The trust terminates and he passes the rest of the assets out immediately. So if the trust owns a house and we both pass away, the trust already says my brother is next in line as a manager, but he has to give it to the beneficiaries according to the trust. So there's no court process, distribution's automatic. The only things you need to think about is the cost is more upfront doing it, and you have to transfer all your assets in it, where you don't have anything under your name, but it's owned under the trust. And it's also not public, where probate for a will or probate for having no will is all public document. This is a private document. No one sees it except you or the bank if you open up a trust account. And that's basically it, generally. I wanted to leave some time for Q&A, for questions, but just to do a quick summary. If you die without a will, Texas has laws in place that'll distribute your assets without your consent. This is who gets them. And it's automatically contradictory to the Quran Sunnah. It's automatically not Islamic, and it's a longer court process, more cost up front. And honestly, it just delays. Even if you have a bank account, someone needs to access it, it could delay it for a year or even more based on the situation or the court you're at. And if you have a will, it makes the court process very seamless, maybe 3 weeks, 4 weeks if everything goes smoothly, but there is still a wait time. And if you have a trust, then you can avoid all of the probate process and still have the same benefits of a will. So in summary, you should at least have a will or a trust as an estate plan. And that's all I have. If you have any questions or anything, I'll be happy to answer them for you. Yes, brother.
Does the state of Texas recognize a will from another state? Meaning I have the will done in the state of Alabama and I moved to Texas. And say I pass away. Is that recognized in this state, or I have to go through the process all over again?
That's a good question. Brother asked if you had a will in Alabama, but does the Texas court accept that will? Generally speaking, yes. if you have a will in another state, but you're living here permanently, I would just have an attorney look at it. Most of them are the same requirements, just make sure you hit the requirements. But let's say you pass away here, and it depends where you probate your will. If all your assets are in Alabama, you probate it there, all you do is file a certified copy of that in the Texas court. You don't have to go through the whole probate process again. You just simply get a copy from where you probated. So you just probate it in one state, wherever that is, based on your assets, and then you just do a certified copy everywhere else you have assets, every other state.
Thank you.
Yes, brother.
What should be done to get the will as a document approved to use? I have it notarized. Is it enough for me to have the will notarized? If there is anything else to be done?
Okay, brother asks what needs to be done to make the will a legal document that's valid in Texas, basically. Texas has specific laws. Every state has their own laws of what makes a will valid. There's a few different requirements. Generally speaking, not in the body of the will, you need to have 2 witnesses. You don't need to have it notarized, but if you do have it notarized, those witnesses can be complete strangers. You never need to see them again, which is the best option to do. And it just has to have specific language. You have to name the executor, beneficiaries. Make sure, I guess, yeah, there's a few different requirements you have to meet, but generally speaking, getting it signed by 2 witnesses, then getting it notarized is what makes it a legal document. And on top of that, if you go to probate for that, you have to make sure the probate court gets the original copy. They will generally not accept a copy of the will. They'll only take the original copy. So the original copy is a legal document you need to hold on to, and that needs to be presented to court at the time of your death. Anyone else?
I have one question.
Yes.
I go through those forms, there are so many pages. So my question is there some way that if I, in a piece of paper, with my ID, everything, attached with my driver license, I sign everything, and in that I type and mention in just one page, according to the Sharia, the Islamic law, I just mentioned, because I saw is a huge, big, lot of different forms. And one brother says the first 4 pages is okay, and then besides those 4 pages, there are more pages. So is that okay if I write in a piece of paper and my will and whatever? Is that going to be acceptable in the Texas?
Brother asked if he handwrites everything he wants, his wishes, is that acceptable? There's something called a holographic will in Texas, where it's a handwritten will. It does need, there's specific requirements for that, but generally the will itself, there are general requirements. I need to see it just to make sure it hits them. And there's a lot of forms out there. I know some masajid have like pre-printed will forms. There's a few issues with that. That's why it's good to have at least an attorney advise you what each thing means. In the charity portion, for instance, it says 10% to this mosque or 10% to this charity. It reads where at 10% of all your assets go there, where that charity might say, I want 10% of the house, you know, so you have to be very clear, 10% cash value. You have to make sure it says independent administration, the type of probate. So there's a lot of little things. It's good to really understand like what each means and make sure it's according to what you want. Because you know, if you write it down, it might not hit all the requirements. When you pass away, the court might say that it's not valid, so it's just like you died without a will. So it's just better to have an attorney at least run through it and make sure the requirements are there, you know, according to Texas law or whatever state you're living in. Did that answer your question?
I believe so.
Okay.
I think at the end we have to see a lawyer just to go through everything okay or not.
I mean,
The main point is that, right?
You don't have to have a lawyer, but there's specific requirements to what makes a will valid. So without me seeing it, you know, attorney is best just to at least let you know it's valid and peace of mind. When you pass away, you know it's a valid will at least, and this is what it does at the time of your death, is what I would say.
Okay. The reason of my question is because we are very simple. We are not a millionaire, billionaire. That we have so much asset and all these that we have to go through all different, you know, sector, you know.
No, you're
simple.
right. Yeah.
So like most of our families, just a house or some bank account. So
I agree.
What are all those pages for? You know?
I agree, and a will shouldn't cost, too much. It should be reasonable, but at the same time, if you don't have a proper in place, your family's gonna have a hard time with your house and your bank account and this, because they're gonna need court approval for each one. You just wanna make sure it's valid and it's doing what you want it to do, to make it as simple as possible for your family, I guess, is what I'm trying to say.
Thank you very much.
Yeah, my pleasure.
Can you just base off your will and just say Sharia law and that's all?
Brother asked, like, if you can write on your will Sharia law. I wouldn't do that. I mean, maybe you could say that. It's Texas specifically is very flexible as far as here's the executor. It meets the requirements. It's signed by 2 witnesses. It's a valid will. Now the executor has to do what's according to the will. If someone disputes it, saying, "Hey, I'm a beneficiary," that's going to be a big issue of what's Sharia law. Like, for instance, for me, I don't even write that. I put percentages and a few different alternatives, like alternative A, B, C, and then you'll know, like, if X, Y, and Z happens, you might need to update the will, because judges just might not look good on it. I don't want them to say, I don't think they will, but I don't want them to say it's invalid, or if it's contested, it might be an issue where, hey, we don't know what's gonna happen, like, we don't know who gets what, we're gonna go based on Texas intestate rules. It's better to be specific on those, because the judge is looking at it, and the judge needs to say, this is who gets what.
Yeah, you have it so trust versus will. Is it either or they're 2 separate?
So it's either or. So if you have a will, that's all you need to do, just sign it. You don't need to transfer property in it. If you have a trust, I include a will with it, but I just call it a trust, because you want all the assets to be owned by the trust, but the will is a safety net. It says, everything in my name, if I pass away, goes to the trust. It's in case you forget to add a house or forget to add a property and they have to go to probate, at least you have a will and it'll make it easier process to put it back in the trust as an umbrella. So yeah, it's one or the other. And if you're not sure, at least have a will. But yeah, trust, you just have to do a little more legwork in the beginning just to make it easier for your family in the future.
So the trust is gonna hold all the assets after you die? And
Yeah.
then distribute it however you laid out the trust?
Exactly, yeah. The trust is gonna hold all your assets until you pass away, and then the trustee, whoever you name, it's generally, family member or whoever, is gonna transfer it. They're gonna have authority to transfer it immediately at the time of your death. Yeah.
And usually trustee is a lawyer, if I'm not mistaken, for real estate?
So brother asked, is a trustee generally a lawyer? So in these trusts, these are revocable trusts. They're meant to be a substitute for a will. So for me, husband and wife are putting our assets in there, so husband and wife are trustees. One passes away, the other is trustee. That just means they have authority over all the assets over there. Both pass away, the trust terminates, and then the next trustee you name has to distribute it out. Kind of works the same way if you have a will going through court and everything, but it kind of avoids that process by doing it all together like that.
I assume the trust is at, for example, 18 years old, you can then give the house to the kid. Or at 15 years old, if they don't graduate high school, you specify how much money they can get or not get. Is that something separate?
Brother asked, is a trust kind of if you have minor children, like specifying if at a certain age they get money or whatnot? Not necessarily true, but same concept with a will or a trust. If your beneficiary is under 18, it's going to go to their guardian, so their parent or whoever is appointed guardian at that time. You have an option with both of them to do a contingent trust. That's just saying if it says if any of my beneficiaries are under 18 and I pass away, then we're going to hold their assets in a separate trust until they're 18, then we're going to release it to them. It just provides extra protection. You can do it in either one. It's not necessarily, it's just called a contingent trust. You can add it to the will or to the trust. It just provides extra protection for your minor children if you don't trust whoever is in charge at that time.
That makes sense. Thank you so much.
Yeah, my pleasure.
What's the cost?
So I'm here giving information session. I can only speak to my prices. Everyone's different. My will's just a simple will. I generally I forgot to mention this part. Each will and each trust should come with these documents. It should come with a guardianship declaration. If you and the mom and dad both passed away, God forbid, kids still under 18 or disabled, you're going to tell the court, this is who I want to be the parent, and this is who I want to be responsible for their finances. It could be one and the same. So the guardianship should be there. Powers of attorney, medical, and financial, and HIPAA release. while you're living, coma, God forbid, or anything like that, you're naming someone to jump in your place to keep your life going and make decisions on your behalf. For me, so these are just my prices. For a simple will, it's $400. Husband and wife, it's $600. Texas is community property. Basically, if you own a house, even if it's under your name and you bought it during marriage, both of you own a half each. So if one passes away, you can, that half still needs to be distributed. So husband and wife generally need to have a will and those estate planning documents. And my trust starts at $1,000 for individual and $1,500 for husband and wife. That includes, any conveyances of property to it. Yes, brother.
Kind of like what he asked. In terms of trustee and distribution, can it be enforced a certain way, or is it upon the mercy of the trustee to distribute however he wants?
Okay, brother asked a good question. Basically, if there's a trustee or executor or someone in charge, can they do whatever they want with it, like distribute it how they want? Yeah, they have full authority to distribute it. However, they have a legally binding document, the will or the trust. They have to distribute it according to there. If they don't, that's, they're a fiduciary at that point. That's a very big penalty. Any beneficiary there can take them to court, and they have to prove everything they've done with this estate. Where did it go? How did you spend it? How did you apportion it? If they kept it to themselves, that's what that document's for, and that's what the court's for. So those are your safeguards for that. But technically, they can do that just for flexibility. But if they don't do what they're supposed to, the court's there to hold them responsible. Yes, sister.
So I know that when a house is passed, usually through a will or there's inheritance, a lot of it is taken out of taxes. Is that the same in a trust, or would that protect the inheritors from the taxes and stuff like that that would be taken if it was just inheritance?
That's a good question. Sister asked, so when people pass away and the assets or the house goes to someone else, there's taxes involved. Does a trust protect against those taxes? There's different types of trusts. This revocable trust does not provide any additional protections as far as taxes. However, your gift tax is in the over 10 million what you can give, but income tax, they just have to self-report and pay whatever income tax of what they inherit. It doesn't protect anything like that because it's a revocable trust. With that, you get the benefits as if you were individual. Taxes, you pay under your social security number. It's not an EIN. If you have a homestead on the house, you keep the homestead and it's not considered a transfer of property because you and your husband, let's say, are trustees. You're transferring it to yourselves as trustees, basically. So you keep all the benefits as if you were an individual, but you don't gain any protections. If you wanted to add asset protection to this trust, the way to do it is through LLCs. You can create LLC and add the house in there, and then incorporate the trust owns the LLC, but the LLC owns the house. I guess if I owned an LLC, I'm the owner of it, but the LLC owns the house. The house is protected from lawsuits, from anything, because I don't own it, but I have authority to sell it, I guess, is what I'm saying. So that's how you provide protections. Yes?
How many trustees could be in a trust?
Okay, sister asked how many trustees in a trust. So because of this and I'm kind of speaking just as an estate planning tool, it's usually whoever owns a property that needs a will or needs a trust, those are the trustees. So husband and wife are generally the trustees, but when they both pass away, they can name 1, 2, 3, whatever they want. I suggest 1 because there's no chance of them arguing or whatnot, but I suggest naming alternatives. If this one doesn't want to take it on or passes away, then this one's in line. But you can name multiple at one time. Yes?
So you want to give something to the grandkids, okay? So you can make their parents to be trustees of the children. So in case you die, they can give the portion, whatever the portion you put in the will. And if children are minor, the parents can hold the money until they get 18 years old. It's the same process, or
Yeah.
something different?
So she asked, you're talking about the contingent trust where the minors, so let's say husband and wife pass away and the minors are there, so they're still holding the money because they're not 18 yet. Thank you. Whoever the trustee you name for the regular trust, so I'm gonna use my example, me and my wife are trustees. If we both pass away, my brother is. And I say, if my kids are under 18, it goes in a separate trust. Just mine, I say, whoever the trustee is of my whole trust is also the trustee of the contingent trust, but you can name a separate trustee for that. You can, because it has its own things, and generally it says you can use money for maintenance, for health, for schooling, but when they turn 18, you give it all to them. So, did that answer your question? Okay. Any other questions? Yes, brother.
What is the process to get a trust or a will in place, and how long is the process?
How long is it?
Yeah.
Brother asked what's the process to do a will or a trust, and how long does it take? So I can speak for myself and generally other attorneys. The first step is, so for me, I ask you to fill out a quick link, just general information, and then we do a Zoom meeting. We talk about the assets, and we draft it, send it to you for review, and review it with you, and usually takes 5 days for a will from beginning to end, about 10 days for a trust because you have to fund it. So really the process is reaching out to an attorney, letting them know your situation. Here, I have wife, kids, these are my assets, and this is what I want to do with it. Then they'll draft something up, review it with you, and then you're ready to sign it. The only additional step with the trust, after you sign it, you fund it. That's when you start transferring all your properties to it. You transfer the house to it, you add the bank accounts to it, so whoever is the trustee at that point can access those assets at the time of your death without the need for probate. Yes, brother.
If the property is mutual ownership, like the deed is the name of husband and wife, is this property mutually owned, will enter any probate?
Brother asked if property is under husband and wife name, let's say.
Yeah.
Is it mutually owned or will it enter probate? Generally, when you see just the names as grantees, husband and wife, with no additional language, it's owned half and half. So if one passes away, the other just still owns a half, and that one half needs to go to probate. Same for this half, unless there's language in there saying joint tenancy, survivorship, that type of language in there. Then it'll go to that one. But then when that one passes away, there's probate there. So if the trust, let's say the trust owns the property, the trust already has a bunch of trustees in line where they have authority to sell it at that point. But generally, it's by default, it's half and half, non-mutually, not jointly. Yeah, like a bank account would be jointly. One passes away, the other owns it, but not for real property. Yes.
I have a couple questions.
Yeah.
First one being, do you still pay the estate tax on a trust and a will? My second question is, can you dab up on how to make a Sharia compliant trust? And the third one, if you have international assets, do you have to also label that in the trust, and is it binding in that respective foreign country that you have it, hypothetically speaking?
Okay, I'm gonna go backwards.
Yeah.
Brother asked, so one of the questions is international assets, can we put it in there? So unfortunately the will or the trust is just under the jurisdiction of USA, so even if you say, hey, look at my will, the other country is not gonna care. They're gonna say, you have to go through our process. A lot of Muslim countries automatically do it like that, but it doesn't matter what you say in the trust or will. Now when you said can you do trust Sharia compliant?
How is a Sharia compliant trust look like?
Okay, it's the same as a will. So the trust is basically, think of it as a will,
Yeah.
but that avoids probate. The trust is saying, this is a contract saying husband and wife are trustees or managers. All these assets are in there, and at the time of husband's death, this is how it's distributed. Then it'll show the Sharia compliant way.
What
And
is that way, that Sharia compliant way?
It depends on who's living at that time. So generally speaking, if you have male children, at least one male child, a wife, father and mother, the father and mother will get, off the top of my mind, 1/6 each. The wife will get 1/8. The kids will get the rest, where the male receives double the share of the female.
Both males or any male? Or
The kids?
if there's 3 males, and 2 women, that's 1/3.
Oh, so yeah, whatever is remaining after giving it to the 1/6 to dad, 1/6 to mom, 1/8 to wife, the rest of it, whatever's remaining, will go. All of it will go where the male gets double the share of the female. So the female or if the male has 2/3, the female will have 1/3 if it's son and daughter. And if for that situation, I believe if the parents pass away, their share will still go to the children. So we'll put language in there. But each situation, you'll let me know your situation, and we'll do a few different alternatives, and that's how you incorporate it in the trust. So yeah, the trust is Sharia compliant, and just a substitute for a will.
Okay. And
Well-
you have to pay estate tax on both.
Yeah, whatever you have to pay on, generally on a will, you will have to pay for a trust. The only thing is the trust is not, it's a private document. So with a will, you have to open probate and you have to give notice to all your creditors, hey, I'm here. If anyone has a claim, you have a couple weeks to give it to me. So that's where they do a claim against your estate. With a trust, they have to open probate to even do a claim. So they have a hurdle.
Okay.
But as far as what I'm saying is, there's no protections, but they have an additional hurdle because you're not opening probate.
Okay.
They have to. Where with a will, you have to open probate. Yeah. Does that make sense?
Yeah, one last one.
Yep.
When you make a trustee, it has to be like a financial service company, or can it be like your local CPA? I know trustees, they can invest it in stocks, bonds, based
Yeah.
on what they have, and they have other protections that come with that.
So brother asked, like, does a trustee have to be like a company or
Yeah, 'cause,
organization?
like, they establish it, and they also
Yeah.
can invest on your behalf.
Not for this. Again, this is a substitute for a will. So the trustees are usually husband and wife. You could have, like, if husband and wife pass away, you could have the next trustee in line a bank, and then they just have to, the trust terminates, they just have to distribute the assets according to the trust at that time. So, but generally speaking, you and your wife want to be trustees because you want to buy property, you want to sell property during your life, and do whatever you want, and then at the time of your death, it's already set up where it distributes. Yeah. Okay. Any other questions? Yes, brother.
If I have over 18 kids, and I know I can give them a board of attorney to ask for my medical record if I'm not able to make decision. But what happened on the flip side? Like for them, do they have to come, and if I'm gonna do a trust or a will, do they have to come and also give me a board of attorney?
As far as like for
them.
Oh,
like
for
if
them?
something happened to
Yeah.
to over 18 kid.
Yeah. So if I understand it right.
And do you do like one trust or one will for the whole family? I can just bring my whole family and give each other.
I see what you're saying. The brother's asking like, he's worried about his kids if they're over 18. Like, does a trust cover everyone? So basically, whenever you talk about I want to get a will or I want to get a trust, you look at you individually. And with husband and wife, you can have a joint trust, but it's not a good idea to have a joint will. But for all your kids, they need to have their own estate plan, because if something happens to them, they need, they're dying without a will, so they need to have their own will. But as far as you and your wife are covered, you can be both covered under the trust, but no one else. They wouldn't have to have their own estate plan, just at the time of death. Yes?
Can you include business under the trust?
Yeah, brother asked, can you include business under the trust? Yes, and that's a very powerful thing to do. So when you create the trust, usually in a situation, what I see maybe 50% of the time, 60%, people have a house, a couple bank accounts, 401k. We incorporate all that in there. The trust owns the house. But if you have rental properties or a business or anything else, I say create a LLC for each one. LLC for this business, LLC for that property. It'll protect them from lawsuits, and it'll provide asset protection for those properties. And there's two ways to do it. The trust gives power of attorney to the trustee. So if your wife's a trustee, you pass away, she has power of attorney over your business assets. What I like to do is do a company agreement or a simple operating agreement if you're the only owner of the LLC, saying at the time of death, the trust is the owner of this LLC, or go ahead and make them the owner of the LLC. And that way you don't have to worry about probate for that asset at all. But yeah, you definitely can incorporate it, and a lot of people do. Yes?
When you have beneficiaries listed on bank accounts or 401k, and if there's a conflict between those beneficiaries listed and what's in the will or trust, like what takes precedence?
That's a great question. Brother asked, if you have beneficiaries on your bank accounts or 401k, they already have beneficiaries listed, what takes precedence? Beneficiary overrides will or trust. So if the bank sees a beneficiary, the beneficiary is the owner of that account. They don't care about a will or trust. It's only when you pass away, there's no beneficiary, that's where the will or trust comes in. Same for 401k, life insurance, all of that. A lot of people do like doing trust. You can't really do that with a will because you can name the trust as beneficiary of your 401k, of your IRA accounts, of your bank account. That way you'll know it flows out Islamically, and you don't have to worry about oh, I'm giving it all to my kids, but what about my parents? You know it's going to go under that umbrella. But yeah, beneficiary overrides trust or will. That takes precedence. Yes.
What's the total value which the government will not get any tax?
My brother asked what's a tax threshold. So I usually defer to an accountant for that. I know it's over 10 million.
13.6.
Okay, he said 13.6. I don't know. He's an accountant.
Accounting major.
Accounting major. So it changes. It changes.
It
all
changes
the time.
every tax code that gets involved. So the new president.
Then it's gonna be a new tax code.
Yeah,
So
13.4 is 13.6.
Yeah.
It used to be 10.3.
it used to be 10.3. Okay, so I know it's over 10 million. So you have that much to give. If you pass away and you give all that to your children, that's all under that threshold. So there's no tax on that. But whatever they get as income tax, they have to pay it as an income tax. That's separate, right?
I don't know what that, but I know it's
Okay.
13.6.
Okay.
Yeah.
Yes, sister.
That 401k we put beneficiary, also our insurance policy. The homes if you own, how can, if you don't have beneficiary, what can you do? Like if you don't have, what can you protect so it goes to
Okay. Okay.
document that one?
Yeah, sister asked, banks, 401ks, you can add beneficiaries, but what about a house? What options do you have? If you wanted to go Islamically, it's a trust, having the trust own it and go through it. If you want, there's transfer on death deed, where it says if they pass away, then it goes here. That's kind of like a beneficiary you can do to the house, so they'll take care of it. It won't be Islamic, but that's what they have in place for real property. Texas does at least. So you do a transfer on death saying, if I pass away, this is the next owner in line. Any other questions?